introduce Gill, who has been in advocacy for ages, haven't you, Gill? You used to be a community advocate and an autism.
Yeah, 2007, I think. So gosh, not as long as Jackie, but you know,
you've got your advocacy stripes.
I guess.
Sure. Yeah. Well, and I first came and kind of across the work of Gill when I was reading. I think I've ever told you this, Gill, but I was reading an article where the lawyers had written a review of being the first kind of remote hearing in COVID, and were writing about how amazing it was, and how this remote hearing was a very useful way to conduct proceedings in the Court of Protection. And then I think it might have been Celia, I think, who wrote
it was Celia Kitzinger, who I co-directed the Open Justice Court of Protection project with.
And she worked with the family, didn't she? And the family's experience of that was completely different.
Yeah, absolutely.
It really resonated with me, just how, you know, these systems that we work in often, they suit professionals, don't they? They don't often suit people. And it was through that piece that I started checking out of the Court of Protection. So your work, saw all your advocacy involvement, and thought, I've got to get this woman involved in our conference. I've got to get them here. So I'm delighted that you're able to come and talk to us today. So thank you so much. So I'm going to hand over to you, and we're going to do questions at the end, aren't we, Gill?
Yeah. Questions, and also I'd really like to, I mean, we've got so many advocates here. We've got like such a great massive gathering of advocates. I don't think I've ever been in a place, a virtual place with so many advocates before. And I'd be really interested in hearing advocates' experiences of the Court of Protection. So anyone who's who's been a witness in the court, or who's used to preparing reports for the Court of Protection, things like that, or anyone who's been a public observer in the way that I'm going to be talking about this afternoon. I'd love to hear people's experiences. Just a little kind of access sort of issue for me. I'm not necessarily going to be that good at reading the comments in the chat and things, so I'm going to be really relying on Kate to kind of like pick out the comments and the questions and sort of like put that across for me.
I will do that. Yeah. So advocates, you've been challenged. Joe wants to hear from you during this talk and after about your experiences. So get connecting. Right, I'm going to turn my video off then, and I'll go do the chat box, Jill, and I'll see you after you talk.
Thank you, Kate, and hello everybody, and welcome to this talk. It is an absolute privilege to be invited to talk at this space with, as I said, so many advocates. Rather daunting to be following Jackie Cowley. I mean, how does one follow that? But yeah, I'm going to do my best. So just to kind of introduce myself and the project and put things in context before I begin. So yes, I'm an advocate. I've been in advocacy in terms of the sector since 2007, and sort of beyond that, I think, you know, how I got into that. It's important to say as well that I'm disabled myself. I'm multiply physically disabled. I have a quite complex health picture, and I'm also autistic myself. And I have kind of a lifetime of experiences of battling. You know, Jackie was talking about battles and fights, and really how we know that accessing the system, whether it be education or health or social care or whatever it might be, is a battle. And that's how it's kind of always felt for me. And when I was younger, I had my parents on my side, you know, as my advocates, when I was in school, and, you know, fighting for my education rights and things. And so that kind of model had always been, well, it had always resonated with my own experiences, I guess. So I kind of came into my adult life, did my first degree in law, and kind of fell into advocacy just because it felt natural. And I was a community advocate, as Kate mentioned. I worked specifically as a specialist autism advocate, so I set up and ran for several years a specialist autism advocacy role within a learning disability advocacy service. And the main aim of that was really to address the gap in services that anybody who's worked with autistic people is probably familiar with. That idea that because we may have mental health issues, but our autism is not in and of itself a mental health condition, and we don't all have learning disabilities. Often a lot of us fall through the gaps. So I was lucky enough, privileged to be in a position to work on addressing that gap in one particular area from an advocacy perspective. And I love advocacy, as has come through from all the comments that I was looking at before in the chat box during Jackie's talk, and what Jackie and Kate have said. I think advocacy is something that that kind of is in us. I think it's probably a set of values that go through us all, like like letters in a stick of rock. I think it's just there, wherever that comes from, whether it be, in my case, it's my own disabled experiences and identity, and other people have all got those reasons why they've got that in them. But I think that's it. And as I left my kind of substantive advocacy role, my first one in 2013, and I work around academia and teaching. At the moment, I'm working as a peer support and development worker for another advocacy project, and everything that I do is kind of around advocacy, even if it's not sort of directly in the advocacy sector, because it's a set of values that I think we take with us. And I think that's probably the flavour of what I'm going to be talking about with this project, the Open Justice Court of Protection project, which I co-founded with Celia Kitzinger, Professor Celia Kitzinger, in June. We launched on June the 15th this year. And the project came about because Celia and I both have experience as public observers in the Court of Protection. Celia, largely through her work with people with prolonged disorders of consciousness and observing serious medical treatment hearings, and supporting family members in that context. And me, as I did part of my PhD research, I did in the Court of Protection in London, at First Avenue House. I was one of the first researchers to use the transparency pilot and the transparency framework that I'm going to be talking about today to get into the Court of Protection and to see what happens actually on the ground. And so Celia and I have both come from that kind of perspective of having different experiences of observing in the Court of Protection and using Court of Protection transparency as researchers and as activists. And then, as Kate began to mention when she was introducing me, Celia was involved again as an observer and a supporter of a family member in the first hearing in the Court of Protection this year that went all remote following the government's introduction of lockdown back in March. I think it was kind of the hearing started like the day after the kind of the announcement had been made, and there was lots of kind of back and forth about whether it was going to be remote or whether it was going to be in court or how it was going to happen. And it ended up being the first all remote hearing. And as Kate mentioned, there was quite a lot of kind of self-congratulation in the media and in sort of the kind of on social media from members of the legal profession about how they managed to make this hearing all remote and kind of, being able to share documents from bundles online and how it had all worked. And kind of, there were kind of a couple of issues with that Celia picked up on and the person she was supporting picked up on. firstly, the lawyers who've written about the experience from their perspective sort of wrote, what was lost for not being in the courtroom, for not being face to face. In reality, not a lot, and that was very definitely not Celia's experience or the experience of the person that she was supporting. They'd found it actually a very traumatic experience to be sitting kind of alone I think they were in a solicitor's office, and most of the time the judge and the lawyers and the parties in the case couldn't actually see her other than when she was giving her witness testimony. Couldn't see the family member, and we're talking about her kind of, I think, sort of as if she wasn't there. And anyway, essentially, they had a very different perspective to the legal professionals, which I think really goes back to what Jackie was talking about stories, and how we all have our different stories, and how sometimes we bring our stories to a particular situation as advocates, as family members, as disabled people, and we find that our stories are up against the stories of professionals and commissioners and judges, and we realise that our stories don't carry as much weight, that our stories are not deemed as important or as credible, and of course that's really where advocacy comes in. So advocacy values, I think, are at the heart of this whole idea of how Celia and I came together, and Celia through wanting to really work out whether remote hearings were always going to be like this, whether her negative experience was a one-off, or whether it was all going to be as kind of disempowering and as traumatic for family members and protected parties at the centre of court hearings. I think she's now observed over 90 hearings since then, and she's kind of come to the conclusion that actually it's not necessarily kind of a negative thing to have a remote hearing. It can work, and it can bring a particular particular experience that can happen. But anyway, so that's how the project came about, that we both had this experience of observing in the Court of Protection, of using transparency in our respective positions as activists and as advocates. And we decided that we would start a project to kind of formalize this, because certainly I've found when I've talked to other people in our kind of sector, the advocacy sector, and people whose work kind of pivots around the Mental Capacity Act, I found that when I said that I was doing research in the Court of Protection, that I was actually going into the court. I spent a month in February 2017, basically turning up at First Avenue House and observing whatever was there. A lot of dolls, case management hearings, directions hearings, the kind of the everyday work of the court, the stuff that doesn't get published in judgments, that doesn't make the media headlines, but that's pivotal in the lives of the people for whom we all advocate. And I found that other people didn't realize that this was possible. They didn't know that it was possible to go and sit in the Court of Protection and observe, not quite in the same way that we would in say the Magistrates Court for criminal hearings. There are obviously transparency, there are restrictions around transparency orders and things, but people didn't know it was possible. So I was kind of passionate about, and Celia obviously together were passionate about making it known that that open justice in the Court of Protection is a thing, is possible, and also supporting people, because as I'll talk about this afternoon, there are some tricky challenges for public observers. There are some kind of technical and bureaucratic issues, and some of the kind of the sort of practicalities are kind of can be challenging, can be daunting. So we're all about supporting people who want to observe what goes on in the court, and also kind of highlighting where we can to the powers that be the kinds of the issues and the challenges that kind of act as impediments to the open justice that the court itself is trying to promote. So that's my rather long introduction to myself and to the court, and to explaining, or trying to explain, how advocacy and activism really is at the heart of kind of everything I've done, and particularly at the heart of this kind of new project, this new venture that I'm co-directing, Celia. So that's an introduction. This afternoon, what I'm going to discuss is, I'm going to give a sort of brief outline of the Court of Protection and its work, and of how transparency in the Court of Protection has come about as an agenda. I'm aware that probably a lot of the people listening will have experience with the Court of Protection, and I'm really interested in hearing about that later. And I'm probably going to be telling you things that you already know, that you've already come across, but especially because I can't see anybody who's listening, and because we're not in the same room together, and there's quite a number of people, I think, who are listening to me now. I don't know what it is that we each know and don't know. So I'm going to try and deliver this talk as though there are kind of no prerequisites. I'm not going to assume too much in the way of knowledge, because hopefully that way we can kind of all progress together, rather than leaving people wondering, well, what does she mean by that, and what's a section 21A, and because actually that's exactly one of the issues that I'm going to talk about, that public observers face in the Court of Protection, the ways in which members of different professions, legal professionals, medical professionals, whoever, talk in their own language, their own sort of coded, jargonized language, in a way that can keep people out. And actually, now that I think about it, and now that I reflect, that in itself is an advocacy imperative, isn't it? It is something with which we as advocates are concerned. The idea of breaking down those barriers to knowledge, and kind of unpicking the kind of the codes and the jargons that professionals can speak in. I don't know how other people feel, but I often used to feel, when I was in best interest meetings, or multidisciplinary team meetings and things with or representing a client, I used to feel that one of the strongest tools that I had in my kind of toolkit, one of the strongest weapons in my arsenal, whether I'm an angel or a part of an army, whichever way you want to look at that, to borrow Kate's phrase, one of the biggest tools that I had was to ask questions, to ask a professional, sorry, what do you mean by that? Can you explain to me what that term means? Can you explain what you're getting at there? Firstly, because often it meant that I and my client would then be able to understand, and secondly, because it would often make the professional themselves think. I think sometimes it's easy to get into that kind of that cozy club where everyone has a consensus of culture and of language and of ways of doing things. I think that also was reflected in what Jackie was talking about the values that professionals bring to an encounter, and how sometimes as advocates we kind of need to shine the spotlight on that body of knowledge as a particular culture, not as kind of some universal truth. So yeah, to kind of to summarize what I'm getting at there, I think what I'm saying is that I'm going to try and reflect in this talk the values that we kind of have within the project, and that I believe to be advocacy values, which are that, in order to have open justice, in order to have transparency, we need to be able to unpick kind of hidden codes, languages, bodies of knowledge, and express them so that they're accessible. So that's what I'm going to try and do today. I'm going to talk about the project as well. I'm going to explain what we do, the different aspects of the project and how they've come about. And I'm going to share some of the experiences that observers have shared with us, have written about via our blog, and have told us about. And I'm going to suggest why you really might want to observe in the Court of Protection, why I think it should be part of the mission of advocates to get involved and to do that. and how you might go about that. So moving on, the Court of Protection and Transparency. So this is the bit that I think will be probably familiar ground to many people, but just to kind of summarize. So the Court of Protection was established in its current form by the Mental Capacity Act 2005. It had existed previously, but its remit really expanded, and it became the institution that we now recognise following the Mental Capacity Act 2005. Its work involves partly making determinations about mental capacity. So if there are disputes about whether a person has capacity to make a certain decision, the court can be the kind of final arbiter of those contestations, those disputes. And it makes best interest decisions on behalf of adults who don't have capacity to make those decisions themselves, in some of the ways that Jackie was talking about earlier. The kinds of impairments that people that P in the court might have that we come across. These are kind of in the order that we've sort of observed them happening in terms of the frequency they come up. So dementia is quite a common impairment that people lacking capacity experience. Learning disability, autism, and psychiatric impairments. And there's such a wide range of cases and of topics and of kind of social domains that become involved and kind of coalesce in the court's work. So health, welfare, property and affairs, deprivation of liberty, safeguards. Those are all kind of areas that come together in the court's work. And I actually think that that's kind of really crucial. That's a really important point to reflect on, because given what I've said, and given again what we've kind of realized through what Jackie was sharing, each of these different sectors brings with it its own set of stories, its own set of assumptions, its embedded culture, frames of reference, and they all meet in the court, sometimes physically, literally, but certainly in terms of the court's work, and the kinds of culture that underpin health, the health service, can often be kind of very different and kind of clash with those of social care professionals. The sets of values that those professionals work towards can really be very different. And I don't know how other people feel about their own advocacy work, their own kind of practice, but one of the things that I felt quite often when I was advocating, particularly when I was doing non-instructed work, was often that the advocate would kind of be in the center of these different sort of, it's almost like there's a wheel with the advocate in the center, and then the different spokes of family members, health, social care, whoever, all kind of around, and you're kind of in the middle of those kind of those sets of values and those different cultures. And I think really that kind of we see that also reflected in the court's work. So that's certainly been another interesting factor for me as an advocate, kind of observing in the court to see how the court kind of handles those differences and those sort of culture clashes. And obviously the work of the court has significant implications for what I call disability justice, kind of the furthering or the hindering the barriers that disabled people face in terms of accessing our rights and accessing society. So it sits, as I've mentioned, in London in either the Royal Courts of Justice or First Avenue House, and it also sits kind of across the regions in county courts and regional courts. There are approximately 30 hearings a day that are scheduled in the Court of Protection across the country, across England and Wales. And as I'll mention, one of the biggest challenges that we've found in terms of the practicalities of being a public observer is actually accessing the listings, finding the details of where all those hearings are happening and of how we actually go about gaining access to them, particularly kind of in the current situation where accessing a hearing generally involves tried to contact a court clerk for a Teams link or dialing in on the phone or whatever. And there's a high percentage of adjournments and vacations, so hearings not happening. Hearing will be listed for the next day, and then you find out at the last minute that it's vacated. It's not happening, and that generally is for very valid reasons. So often the sides, the different parties in a case will be talking and working up to the last minute, and if they reach agreement and find that they don't need to go before the court, then of course it makes sense and it's right not to hold the hearing. Those are all kind of very valid, often very can be very proper kind of reasons for that happening. But it does have an impact on observers who might have kind of cleared a day in their schedule. They might be, some of our observers have been kind of professionals, social workers, other professionals who might be using their annual leave to observe what's going on in the court. And it can be a little bit tricky when they've done that and then the hearing they were planning to observe doesn't happen. So we've started kind of working with supporting observers to maybe schedule a first choice and then a second and then a third. Hopefully one of those will actually go ahead and we'll get access to it. We'll discuss that shortly. A key issue about the court of protection in terms of kind of transparency for me and of how we as a public scrutinize the work of the court is that there are actually really low numbers of judgments from the court that actually get published. So I checked out, I went on Bailey, which is the British and Irish Legal Information Institute website, where for anyone who doesn't know it, you can kind of access judgments that are published from courts across all the jurisdictions that we have. And I checked out how many judgments were on there for the Court of Protection for the last 5 years. And I found that in 2015, 85 judgments from the Court of Protection were published. 2016, it was 66. 2017, it was 31. 2018, it was 38. And 2019, it was 58. And of course, that's the last full year that we have. And this is out of thousands of hearings that happen every year in the court across England and Wales. So I mentioned that there are kind of 25 to 30 hearings happening per day. That's a lot of work that is kind of going on in the court that is not being published in a judgment. Now, most of the time, that's because the hearings that are happening every day, those 25 and 30, are they're not hearings that produce a judgment. So they're directions hearings or case management hearings or other kinds of work that don't have a final judgment to them. So it wouldn't be expected that every hearing would produce a judgment by any stretch. But nevertheless, this is a lot of the court's work that is happening that is not available to be scrutinized simply by checking online and reading the judgment. Judgments are a great way of understanding case law and of kind of informing ourselves about how the law works and how it's interpreted by judges, but there's an awful lot of work going on that kind of we don't see, and certainly my experience when I was observing in the court, sort of again taking my sort of advocacy perspective, was that I got so much out of listening to the proceedings, having them unfold in front of me. Seeing how in one hearing when P himself was present, how the court kind of responded to that and what the kind of challenges were for that, and how it was facilitated and how P's voice was heard. In a hearing where there was a respondent who was a litigant in person, how the court kind of worked towards making sure that, or doing its best to make sure that he was able to kind of give his case as well as he possibly could, although he was against a represented party, so somebody who had a barrister there representing him. These things that are all part of how the court works and how the court particularly works to ensure that voices are heard and that participation happens are generally not things that make their way into a judgment. The only way that we can see those happen is by actually being there, sitting there and kind of watching it unfold. And certainly for me, I think probably as advocates, we can all reflect and think that the things that really make a difference to us in our practice and the things that we take with us that kind of sustain us in terms of why we do what we do, why we're passionate about what we do, are those very human moments, those moments where you know that you sat and had a conversation with somebody and you remember the look on their face and the tone of their voice and the way that they explain things to you. They don't tend to come across always in reports. Obviously, there's a place for paperwork and documentation, but so much of, I think, the heart of advocacy practice is really in that kind of interpersonal human space. And certainly that's what I see when I observe in court. So yeah, that's the court. In terms of the Court of Protection and Transparency, as you're probably aware, the idea of transparency, the principle of transparency, has been kind of an ongoing saga really since the court in its current form was established in the Mental Capacity Act. This quote, I think, really from Lord Justice Toulson, really kind of underpins the kind of ethos of transparency in the Court of Protection. It says, "Open justice. The words express a principle at the heart of our system of justice and vital to the rule of law. The rule of law is a fine concept, but fine words butter no parsnips. How is the rule of law itself to be policed? It is an age-old question. Who will guard the guards themselves? In a democracy where power depends on the consent of the people governed, the answer must lie in the transparency of the legal process. Open justice lets in the light and allows the public to scrutinise the workings of the law, for better or worse." And then he quotes from Jeremy Bentham, who said in a well-known passage that had previously been quoted in case law, "Publicity is the very soul of justice. It is the keenest spur to exertion and the surest of all guards against improbity. It keeps the judge himself while trying under trial." And I reflect on that from my advocate standpoint, and I see so much in there that reflects what we often are about as advocates. I think, for example, of the kind of the framework of the watching brief and how so often so much of our work we describe in terms of observing and scrutinizing the practice of professionals who have roles and power and authority in the lives of our clients. And we scrutinize to make sure that the person's rights are upheld, to make sure that that laws and other frameworks of governance that are applied to the power and authority of the kind of the roles of professionals in different contexts really are followed and upheld. That's part of what we do as advocates. And here, Lord Justice Toulson, to me, is explaining how open justice and transparency in the court context are really the ways in which we take through that kind of that watching brief, that scrutiny into the work of the court. So that's the kind of the conceptual, the sort of ideological framework behind transparency and where it sits in terms of what the judiciary itself thinks it's about with transparency. So in practice, transparency has had a bit of a kind of an interesting history in how it's developed. So you probably come across, and it's probably no secret that the Court of Protection is often described in the media as a secret court. the media, certain members of the media really do tend to go to town on the kind of sensationalist headlines that happen when they pick up a judgment that sounds sensational, and they stick secret court in front of it and adjectives like shadowy, and they say that that all these things are happening and people's liberties are being taken away, and it's all happening in secret. And that sounds very shocking, and it possibly makes headlines and sells papers. But the extent to which it's true is well, it's not true. So from 2007, when the court was set up in its current form, most hearings were heard in private. There have always been some exceptions. So serious medical treatment and committals to prison were always held in public. But the court has always been concerned with a balance between public interest and the privacy of the people who are at the centre of hearings. So the court has kind of seen that as a sort of a balance between different aspects of human rights. So Article 8, which is the right to privacy and family life of P and P's family. But on the flip side, Article 10, which is kind of the right to freedom of expression, and to the kind of the public interest side of accessing the court and the court's proceedings. From 2009, there was kind of an ongoing series of cases where the press and media kind of took action to try and gain access to the court, and in each of those judgments there are discussions about this balance between privacy and public interest. And then in 2016 we got the Court of Protection Transparency Pilot, which was the framework that I was able to use to be able to go and sit in the court as a member of the public, and having signed a transparency order, which basically generally means that I promise not to reveal the names of any parties, not to reveal the identity of P, or sorry, not the names of any parties, because like you probably know, the names of the public bodies who are often the applicants in court proceedings are generally named, but the names of protected parties are not, for the reason of protecting their privacy. So after I've signed to say that I'm not gonna do any of that, I can go and sit in the court as a member of the public. I don't need to be accredited press. I don't need to be a formal legal blogger, which is its own set of framework that applies to the family court. I can just be a member of the public and go and see what's going on in the court. And that started in 2016 and was formalised, became part of the procedural rules for the Court of Protection in 2017. And it flipped the assumption. So rather than there being a presumption that most hearings would be heard in private, the assumption became that most hearings would be in public with reporting restrictions. So when you see headlines now stating that the Court of Protection is a secret court and that the public doesn't have access to what's going on, I think really that the kind of the reason for that kind of lays more at the feet of the media than the court itself. I certainly never saw a member of the press in any of the hearings that I observed. So, you know, go figure, as they say. And more than that, there's a sort of an ideological and a conceptual commitment to the principle of transparency from the judiciary itself. Transparency is central to the culture of the Court of Protection, says Mr. Justice Hayden, who's the Vice President of Court of Protection. So when it comes to us as the Open Justice Court of Protection project, trying to facilitate access to the court, really we're kind of pushing against an open door and trying to work together with the court as much as possible to try and make that happen. But there has still been and always has been low public attendance at hearings, and that creates its own kind of tension because there are costs to transparency. So for court staff, they have to prepare the relevant paperwork for the transparency orders for each hearing that happens under the transparency framework. And there are various things that have to happen that add to the workload of court staff. Barristers have to make sure that their position statements, skeleton arguments, etc., are kind of anonymized so that they can theoretically be given to public observers. So it creates a workload. And then when nobody comes, no members of the public come, it kind of it sort of gets their back up. So when I was in the court doing my observations, I kind of encountered a bit of hostility towards the idea of transparency, not in theory, but certainly in practice. And one of the great things about the project has been being able to show that actually there is an interest, a public interest. If you explain to people and support people in accessing the court, they do come and they are interested, and they certainly get a lot from it. There are various access challenges though, which as a project we're kind of we're engaged in highlighting and addressing. So some of the practicalities around transparency, just to run these through very quickly. There's short notice for kind of details of accessing hearings. Listings are published every evening for the next day, so it can be very difficult, particularly in the days when hearings happened in person and an observer might have to travel to the court itself. Getting the details of the hearing the night before can often be kind of impractical. As I've said, significant numbers of hearings that are listed don't go ahead. Inaccurate contact details appearing in listings is a frustratingly common occurrence. Incorrect email addresses, incorrect details of where to email to gain access. Very frustrating for public observers, and a total practical barrier to access. Lack of information about the hearings themselves and what are going to be involved. Under-resourced courts, overstretched staff, delays in responding to observers' requests to access the court, delays for judges receiving those requests, last-minute access arrangements, delays in starting the hearings and finishing the hearings that mean that observers often don't know how much time to set aside or end up having to stay to finish observing a hearing that they might have thought would have finished already. And also issues that are issues that happen that for example, sometimes observers say to us as the project that they want to observe a hearing about a particular impairment group, autism, for example, and we can't really help with that because that's not information that is provided about hearings. Or they might say that they want to see a specific issue, dolls or contact decisions, things like that, and we can't always help with that. But there are things that we can help with, which are if an observer wants to observe in a specific geographical location, that's obviously available. We can tell them about that. Or if they want to see a certain judge, that's also possible as well. Sometimes we've had observers contact us who want to observe proceedings because they themselves are involved in court of protection proceedings and they want to see what's going on. That might involve they want to see a judge that they know they're going to come before themselves. So those are some of the reasons, those are some of the practical issues with transparency. So where hearings are listed and where they're held, the Court of Protection, as I've said, sits in 3 places. So it sits in the Family Division of the High Court. That's when you're before, the proceedings are before Tier 3 judges, the High Court judges. Mr. and Mrs. Justice X are in the High Court, or the Central Family Court, which is where I did my research, or the regional court. And each of those different areas, different places, has its own set of listings. So one of the things that we do as a project is that we collate all those listings and we put them out via our Twitter feed and on our website, so that people who want to observe, members of the public who want to observe, don't have to troll through all those rather inaccessible sources. We bring them all together for people. And how hearings are listed. So as I mentioned, observers might want to hear specific details, might want to see specific types of hearing. And that's not always possible. If we see, so the top left there, the image there, all that really gives you about hearing is the time, the case number, the judge, and where it's going to happen. Not much use if you want to know whether you might want to observe that or not. The one below that, slightly better, it gives us a time estimate of 1 hour, and it tells us, it confirms for us that it's going to be a remote hearing, because it says it's going to happen by telephone. So a little bit more information there. On the right is a listing that's actually much more of a kind of an exemplar. It's what we might want to see, because it gives details of what's going to be addressed in the hearing. And also at the bottom, it gives details of how anyone who wants to observe should go about that, the email address or the phone number that they should contact. That's an exemplar, but it's far from common at the moment. So the project and what we do. The things that we do as the Open Justice Court of Protection project include having launched on 15th of June 2020, we share court listings, as I mentioned. We provide information and practical support to public observers. We report on hearings we've observed via our blog. We provide links to published judgments, and that's kind of a key part of what we're trying to do about informing the public about the work of the court. So if we've provided a blog commentary on a particular hearing and there is a published judgment, we go back and we link to that in the blog as well, so that people can see the two sides of the hearing. We share updates on developments around the Court of Protection, and we're using our experiences as public observers to kind of impact the development of open justice in the Court of Protection. So very recently, Celia she was invited to talk to the as part of the induction process for the next batch of Court of Protection judges that are kind of going through their induction, and she gave a talk from a perspective of public observers and sort of said, really, there's some of the things that we need and that would help make proceedings more transparent. We also share details on Twitter of all the hearings that are kind of going on, so that people can kind of have a wider choice, and that's our Twitter handle. On the website, we've got various things. What we tend to do, because of some of the issues that I mentioned around the difficulties of practically accessing hearings, what we do every day is we pick out what we call featured hearings. These are the ones that we think are most likely to be accessible to the public, that the public are most likely to have success in accessing and most likely to find kind of interesting and engaging. And we put those on our website as featured hearings. We also provide support and information to public observers about what to expect and how to go about observing. That's our website there, openjusticecourtofprotection.org. And one of the things we've done recently is, because we found that one of the biggest barriers to transparency for the court public observers was actually making sense of what they saw. Kind of like we've kind of experienced as advocates, becoming sort of launched into the court is a bit like going into a professionals meeting where a case might be halfway through and everybody else knows what's going on and you don't. And observing a hearing can be very much like that. So we've created this feedback form as a way of supporting observers to kind of structure what they're seeing and kind of know what to look out for. And that's downloadable from our website. We have a blog. We've published, since we started, we've published over 60 blogs from public observers, most of whom have been health and social care professionals. Some have been aspiring lawyers and also family members who are going through Court of Protection proceedings themselves, and a few others as well. And we've also commissioned explainer pieces from those who work in the Court of Protection in different capacities to try and provide information about the role of the court from a kind of a practitioner perspective. So observers' experiences, what have observers found and shared with us? I'm aware that I'm kind of coming to the end of my talk now, but this is really the kind of the crux of what people have found. One of the things that has really surprised and delighted several of our observers has been the person-centered way in which decision-making has happened in the courts. So, for example, human rights has become real and applied. I can see more clearly that down at the coalface, we have real opportunity to empower our service users. And based on what I have observed, I have confidence that if the situation of our service users should ever require consideration by the Court of Protection, the judge will ensure their right to participate is facilitated and their right to self-determination, if at all possible, is respected. And I know that when I was an advocate, when transparency and access to the court wasn't possible like this, anytime I heard the Court of Protection mentioned, I would have loved to know what actually went on in practice and what it looked like. And this kind of information would have been so impactful to my advocacy, I think. There's some more quotes there that you can read when the slides are going to be shared. All of these slides are going to be shared via Kate after the session, and the embedded links you'll be able to follow through and read up for yourselves. So some of the things that observers don't find, as I've mentioned, it can be challenging to make sense of what observers see in court. Some of the things that are being promoted now, both by the judiciary themselves, and also we're kind of reflecting where we can, are things like an introductory summary at the start of a hearing. I mean, that seems to me like it is just a good idea at the start of any hearing to kind of sum up who we are and why we're here. But yeah, lots of kind of technical challenges that observers experience. So why observe in the Court of Protection? I'm going to kind of finish with just this quote from Hilary Paxton, who was a trainee IMCA who wrote a blog for us, and this is what she got from observing with the court, in the Court of Protection, and then writing blogging for us. She said, "In terms of my role as an IMCA or an RPR, I learned that it's essential to be even-handed and remain as calm as possible when contributing in court. There can be so many emotions involved for family members, and as a professional, it is essential that all the evidence is available before the judge can make a decision in the best interests of the person at the centre of proceedings." So Hilary got a sense there that observing was going to impact her practice and kind of inform her about the work of the court. I'd suggest that there are two other kind of more ideological reasons why advocates should attend Court of Protection, why observing the court's work is an advocacy imperative. And I think that they really are to do with the watching brief and to do with bearing witness. I think that as advocates, we can scrutinise the work of the court, hold it to account where appropriate, and that we've done that through our blog several times, where people have really questioned what the court has done and given a voice to that kind of scrutinising. And importantly, and tying in with kind of what Jackie was talking about earlier, we can bear witness to the stories of the people whose lives are being impacted by the work of the Court of Protection. I know that when I was an observer in the court, I went away from the court carrying those stories with me. You know, sometimes they moved me to tears, sometimes I was so impacted by them, but I could sit and talk to you about them now. And those are parts of that person's life, that story that I've brought with me, and they've impacted my own life and my own views. There's quite a lot more in here that I really don't have time to cover today, but it'll be there for when you want to take a kind of a tour of these slides yourselves. Hopefully the slides themselves will act as a kind of an introduction to our project and provide some food for thought about why you might want to observe Court of Protection in action as advocates, and potentially why you might want to write for us on our blog. We'd love to hear from you. There's our contact details. Yeah, I think we maybe have a couple of minutes for questions, but I'm sorry, it's not a great deal of time. So thank you. Thanks for listening.
Amazing. Loads of comments in the chat box.
Okay.
We've got 3 minutes and 10 questions.
Sorry, that is really tight.
It's fine. If you're okay should we do a couple, see where we get to?
Absolutely, please. Yeah.
And lots of people I think want to connect. So maybe Excellent. We will put your contact. Oh, I think I put your contact details at the top, did I? No, that was Jackie.
They're on the end of the slides. So if you're going to share people's slides, the slides with people, they'll be able to get in touch there. It's all on there. And
great.
Yeah.
Well, yeah, but we just shouted out for a whoop whoop if you wanted to be an observer, and loads of people have just gone whoop whoop. So
right.
I think, and we talked, didn't we, Jill, previously about hooking up formally to get advocacy training, and then other people have said, well, if I'm qualified and want CPD experience, maybe I could become an observer. So
I mean that's kind of another part of the project that kind of I didn't talk about, that actually we're working with advocate organisations and law clinics and things to kind of do that partnership.
So we're keeping on that. Lots of support from group members. Okay, so lots of kind of comments around remote hearings not including the advocate or not including the person or the paid RPR. Any thoughts or advice on what advocates can do to kind of address that?
Off the top of my head, in terms of what to do, not really. Sorry. I think one thing that I that's mainly because I'm not so sure on the ground in terms of how advocates engage with the court's work itself. That's not something that I've sort of come across in practice, like the practicalities of how how
that's
you
fine. Don't worry. We'll move.
But I think one thing that I would say as a kind of flip side is that we've experienced that actually in some cases remote hearings have enabled participation in a way that wouldn't have been possible in the physical court. There's one case that's on that's blogged about on our blog, that was a guy who was on hunger strike, and he wanted to participate, but he didn't want public observers to see him because he's very sort of emaciated and didn't want to be seen like that. So it was possible for the court to hear his voice, but not to see him and things. So there are ways like that actually sometimes, that it is possible to kind of to make those adjustments, and the court does in some instances. And I guess the more we know about that and about the good side, the more it should kind of act as a kind of like a sort of be sort of a tool for getting people to do it, basically.
Beautiful.
Saying, look, it's possible.
And that leads into another question then. So very quickly, a couple of people asked around what type of adjustments have you seen courts make to enable the person to participate?
So there's the one that I mentioned about I mean, that blog, I would seriously recommend that anyone goes on our blog and looks at that. It's called Hunger Striking for His Identity, I think. And I haven't got time to talk about it right now, but it's such a powerful case. And so that was an instance where I mean P was fully participating, fully kind of engaging, and was basically sort of conducting his own engaging with his own hearing from his hospital bed, basically. So that's sort of one of the adjustments. I would say that I've also seen some of the challenges that the court faces. So when I was in the court myself doing my observations in the one hearing out of 14 where P was actually present, P was a wheelchair user and a hearing aid user, and was relying on the hearing aid loop to participate, and it kept cutting out, and he kept getting like interference. So he kept saying, it feels like I'm having bricks thrown at my head and things. And the judge and the kind of the professionals around were the ones who were doing everything they could to try and mitigate that, to try and make sure that if he wanted to be heard in to talk to the judge in a different room, things like that they were happening. And it did sort of seem, in fact, a lot of the time my observations have been that there is a general willingness to try and make something work, but often I think there are two factors that get in the way. So one is the kind of the practical, the sort of infrastructure, it's just not very good. And the second is just the kind of the knowledge and and that's another way that I think advocates, and particularly kind of people with lived experience, can really contribute, in that we've got a set of knowledge that actually just isn't available to, or isn't within the grasp of legal professionals. And I think the more that we recognize that for ourselves, even if they don't, you know,
and I think sometimes we can talk ourselves out of a role. I mean, I know Jackie was talking about that and literally being instructed, but in this context, we can do that, can't we? We can push for those adjustments. We need to be the ones shouting about, talking directly to the person where they want to. So yeah, it's but yeah, loads honestly, Jill, when you read the chat.
Yeah, I'm just noticing actually in the chat, Monica said about how, you know, she wanted to shadow in the Court of Protection, but it came to nothing. And that's exactly the reason why, you know, I sort of feel so strongly about this, because, you know, as an advocate, the Court of Protection, anytime it came up in any of my cases, just felt daunting, because I didn't have, like, even, you know, imagining what the court would look like. There was no reference point in my head.
Yes.
So I think even if as advocates, if we just know what it looks like, what a judge might look like, you know, the fact that
it's not as
wear wigs and gowns, and they don't, you know, so much of our understanding of like the law and the court comes from TV, you know, drama representations and things, and they're so different. That's our choice, you know.
With much respect, I think, coming through the chat room. But Jill, thank you so much. That was amazing.
Thanks for inviting me, Kate, and thanks for, like I said, I don't think I've ever been in the presence or the virtual presence of so many advocates.
150 today.
I mean, that's just rocking, isn't it?
Yeah.
Like, thank you everyone for listening.
Brilliant. We'll definitely be in touch, and I think for people on the session, you know, we will be in touch about opportunities to share
and you know, connect on Twitter and you know, by the website and things. And there's a contact page on the website as well, so that's the way of getting in touch.
Stay in touch with you.
Yeah.
All right then, guys. Well, our last session will be kicking off in about 20 minutes.
Sorry, we've gone over a bit, haven't we?
Don't worry, it's fine. We have half an hour in between.
Excellent.
I don't know whether anybody's started on the wine yet. I know but each to their own. But we've got Kirsty Stewart talking next about using the Court of Protection to help get people out of long stay hospitals. So really important topic. Yeah. All right then, guys. Well, I'll see you shortly then. All right. Thanks again, Jill.
Excellent. Thanks, everyone.
Okay. Bye.
Bye, everyone.